Hi, good afternoon, or should I say good evening or good night? Depends on where you are in the world. Thank you so much for joining us for another Tech Talk Tuesday. Tech Talk Tuesdays is brought to you by the Jamaica Technology and Digital Alliance. I'm your host, Andrew Nooks, and we are here to bring you the latest insights and discussions over the ever-evolving world of technology. Get ready to take a dive into today's topic. Get prepared for Jamaica's Data Protection Act. The world of technology is constantly advancing, and with that progress comes the need for robust measures to protect valuable data. In today's episode, we will explore the upcoming Data Protection Act and how it will impact businesses as well as individuals in Jamaica. The Data Protection Act is designed to safeguard the privacy and security of personal data for the purpose of protecting the people who the data is about. In other words, this empowers individuals and give them control over their information. As technology continues to shape our lives, it's crucial for organizations to understand the implications and ensure compliance with the new legislation. In this episode, we're joined by experts, Ms. Celia Barclay, Jamaica's Information Commissioner, Georgia Henlin Gibson from PLMC, and Chukwuemeka Cameron, Chuck, I hope I said that right, from Design Privacy, to shed light on key aspects of the Jamaica Data Protection Act. We'll discuss the importance of the Act, the rights of individuals, and the responsibilities of organizations that collect and determine how data is used. And hopefully, by the end of this session, we'll be able to give you some practical steps and guidance in going through and implementing your program. So, before jumping into it, let me give my panelists their due by introducing them. And I'll start with Mrs. Georgia Gibson Henlin KC. I almost said QC. I mean, that's no more, right? It's Georgia Gibson Henlin KC. She's a founder and chief governance, risk, and compliance specialist at Privacy and Legal Management Consultants Limited. Seems like a mouthful. Georgia Gibson Henlin is the founder. PLMC specializes in governance, risk, and compliance in the areas of data protection, corporate governance, and anti-money laundering. Its main area of focus is data protection, wherein they work with companies to operationalize local and international data protection laws and regulations in their organization. This includes training and data protection implementation plans. Georgia is a King's Counsel at the Jamaican Bar and is also called to the bar in Ontario, Canada, and in New York in the United States of America. So give welcome to Georgia. I mean, there's a lot more that can be said about Georgia on this, but if I'm going to read the profile of everyone on this call in full, we're going to take the full hour to do that. Now, this lady has been making the rounds, right? I was saying to her earlier that, boy, nobody remembers her name because everybody refers to her as Information Commissioner. So help me make welcome Jamaica's first Information Commissioner, Ms. Celia Barclay, who holds both a Bachelor of Arts and a Bachelor of Laws degree from the University of the West Indies. She completed her certificate of legal education at the Normal Manley Law School and was called to practice as an attorney at law at the Jamaican Bar in 2007. In her over 14 years as an attorney, Ms. Barclay has practiced at the private bar and served as a legal officer in the public sector in the roles of trustee in bankruptcy, government trustee, and deputy administrator general. In these capacities, she garnered experience in several areas of law and developed key skills in areas of management and administration. Now tasked with giving strategic direction to the newly established Office of the Information Commissioner, Ms. Barclay is committed to using her knowledge and experience to create a regulatory authority which will operate with efficiency, transparency, and accountability in ensuring the protection of personal data in Jamaica. She believes that stakeholder engagement at all critical stages is key to fostering buy-in to new systems and ensuring optical compliance with laws, regulations, policies, and procedures that govern people in the conduct of their business and their dealings with one another. So make welcome, Celia Barclay. everyone. Now, Chuck Cameron, I don't want to bite my tongue, but let me try again. Chukwuemeka Cameron is the founder of Design Privacy, a consultancy firm that helps companies comply with the local and international privacy laws. He believes that by protecting informational rights and by complying with the privacy laws, allow for the free flow of information and ultimately generation of wealth. And if you know Chuck, Chuck is always going to be talking about generation of wealth. He's an experienced attorney with 23 years at the bar and has demonstrated a history of working in regulatory compliance in the telecom and financial industry. He's skilled in privacy law, commercial law, and copyright law. He's a strong professional with a master's in information technology and management from Erasmus University. Listen, that is a whole different language, in Rotterdam, with a focus on data protection, and in 2019 completed an advanced masterclass training as a data protection officer from the ISO certified provider IT Governance UK in the United Kingdom. So ladies and gentlemen, please make welcome to our panelists. Now, what our topic today is about data protection. And data protection, I like to look at it as the protection of data in order to protect the rights and freedoms of the people who the data is about. But let me start off with the commissioner in this discussion. Commissioner, could you please enlighten us? What is this data protection law and what is it about and who does it affect?
Well, Andrew, I think you summarized it quite well in your intro when you said that the Act is there essentially to ensure that there is protection for persons' privacy rights, specifically as it relates to personal data. And so when we talk about the affected persons, it's everyone. It's you, it's me, it's the persons on this call. It is everyone from the little child to the elderly to even deceased persons who have passed away within the past 30 years. We're looking at ensuring that any personal information relating to these individuals by which they can be identified and that is in the hands of other persons is treated with respect and properly protected, particularly against misuse. So that is essentially what the Data Protection Act provides for.
Yeah, that's quite interesting, Commissioner. And in my reading and research of Data Protection Act, it speaks about some principles and stuff. But Chuck, how does this really impact organizations? Because this talks about organizations having to comply with this Data Protection Act. How does this impact organizations?
So the legislation really places an obligation on organizations who process people's personal data to protect the personal data and to safeguard the personal data. And how they have done this, they have prescribed specific data processing standards that these organizations are mandated to implement. So not only does the legislation say that everybody here has rights, right, the legislation has gone further and says in order to protect those rights, these are the data processing standards and the privacy framework all organizations or persons that process personal data for business purposes must implement. So it is a very robust framework that just not only give rights, but puts a mechanism in place to ensure that they are indeed enabled and recognized and protected.
You mentioned framework about twice in your remark, Chuck. This framework that we're talking about, is this the law that we're talking about that sets the framework? What is the framework that you just mentioned?
Well, the first thing I want to say is what the framework is not. The framework is not complete in a form or rights in a privacy policy. That is not what the framework is, and that's the first thing. So the framework, when we make reference to the framework, it is primarily that framework that is established in the legislation that contemplates, one, the data processing standards, that contemplates, two, those policies and processes that must be put in place to enable the data subject rights, because the legislation as I said, not only sets out those data processing standards, but it says you must put in place certain mechanisms to ensure that data subject can exercise their rights. So when you marry the data processing standards and the mechanisms that you are prescribed to put in place, that's what we refer to when we use the word framework.
Yeah. Okay. Georgia, Chuck mentioned data subject rights. Who are data subject and what are these rights that we're talking about? I mean, are you saying that I have rights under this Data Protection Act? What are they?
Well, the data subject is not identified in the act. There's no definition for the data subject, but the way in which the act talks around or about the data subject, you realize by definition, when it says that it's a natural living person, then you know that it's talking about everyone. I like to refer to the Data Protection Act, and these days I tend to compare it with the Road Traffic Act. In other words, it touches everyone and it concerns everyone. So the data subject rights are, the right to consent to the use of their data, because as you started out by saying that the Data Protection Act is about privacy rights. And because those privacy rights are owned, or the data subject has dominion over them, I like to say that the Data Protection Act presents that methodology or legal methodology by which persons can have legal access to this data over which we each have dominion. So it gives us these rights, which is the right to consent, the right to rectification, the right of access, the right to be informed, and to data portability. Those are the rights of the data subject.
Great. Thank you so much. Now, Ms. Barclay, in an article or a publication in one of our newspapers, you had asked, suggested some questions that organizations must ask themselves in terms of, knowing whether or not they are ready for the data protection legislation. You want to elaborate a little bit about what organizations should do or what questions they ought to be asking at this point in time in getting ready for data protection, compliance with the Data Protection Act?
All right. So when you're looking at the Data Protection Act, as has been mentioned before, the Act imposes certain obligations on individuals. So essentially, we are currently in a 2-year transitional period that allows organizations and data controllers generally to get themselves ready for full implementation of the Act. Now, what that means is, come December 1, 2023, when the Act comes into full effect, persons are expected to not just be ready to register with the Information Commissioner's Office, but also to be in a position to comply fully with the requirements of the legislation. And so you have to look at how each of those obligations impact on your particular organization and see whether or not you are meeting those requirements. So first and foremost, you have to look at, for example, you are collecting information from various persons. Let us start with the basics. Do you have persons' consent to hold and process that information in different ways? Many times we acquire information from various means. It might not be from the individuals themselves. It could be from third-party sources. You have to assess your organization, not just in terms of the types of information that you hold, but how is it that that information is being processed? You have to look at what are some of the purposes for which you're processing this information. And then, because a lot of organizations have been around for numerous years, you might be holding information for persons that you no longer have any dealings with. Sometimes we do have a habit of storing information for excessive periods of time. We also have made it a culture to be collecting more information than might be necessary to provide a particular service or to carry out a particular process. So organizations have to look at themselves, recognize now that as a data controller, each of the standards that are prescribed in the Act apply to you, and ask yourself, are you really meeting these standards? Have you satisfied all the requirements? If you have not, then this is where you not necessarily cease operating, but certainly reconsider in terms of how you're operating and look at how you need to get help. So one of the first things we do, we encourage persons to reach out to a privacy practitioner and have an initial consultation. Because persons, for example, like Mrs. Gibson, Henlin, Mr. Cameron, and others out there are in a position to come in, do an initial assessment of you, your processes, have a discussion with you in terms of what your role and functions are as an organization, how the Act relates to you specifically, and they can give you guidance as to steps that you now need to take to ensure that you're compliant. Chuck mentioned a privacy framework that goes beyond just simply saying, well, we have a data protection policy. You have to look at, do you have a full privacy management team in place? Have you created not just policies, but procedures as to how to treat with different situations? So the Act provides for the data subjects to have certain rights, but have you built out the procedure that will facilitate subjects in accessing those rights? How is a request to be made to you? What are the timelines for responding to it? What is the mode and manner in which you are going to provide a response? If it is that the person is reaching out to you with a complaint, how is it that you are going to investigate and treat with this complaint? And most importantly, because we recognize that anything is possible, things can happen, persons may fall short of a particular requirement, or you might come under some kind of external attack. Do you have some kind of mechanism or procedure in place to treat with how you respond to those situations? What do you have within your organization to ensure that you're in a position to, for example, not just take quick action to rectify a breach, but you are required to report any contravention to the commissioner within a period of 72 days. So you have a mechanism in place that will allow you to put in all the necessary information into a report and submit to the commissioner in a timely manner. If you have to notify the numerous affected data subjects, which can be plenty, what do you have in place to ensure that you can do so effectively? How up to date are your contact details, for example, for these persons? So there's a lot that goes into preparation, but what is critical is that persons get started now.
Yeah. Celia,
you spoke about 72
days, right? 72 hours, right?
Hours. Certainly not days.
I was wondering, I saw Chuck reacted to that also, right, Chuck?
Correct.
Right. The time has been extended.
I also want to do, I think a disservice was done to the moderator because of the fact that he's playing the role of a moderator, but persons following this can contact either of us because he's not only a moderator. When you put my resume and Georgia's resume together, that's his resume.
Boy, Chuck, thank you so much for that. But you're being very modest where that is concerned, and I appreciate that. Thank you so much.
But today, I would like to endorse what Chuck said.
Yeah. I sit in the role today. Normally, we sit on the panel together. I sit in the role today as moderator, as I'm representing as a council member of the JTDA, who was asked me to sit in this capacity. But so today, though, I want you guys to highlight, some of the important things. I hear the commissioner mention a couple of times. She keeps saying organizations, right? I want to know, who are those organizations that need to comply with this act? What organizations are we talking about? Are we talking about the mom and pop shop? Are we talking about schools, churches? Are we talking just about big financial institutions? Georgia, you want to take a stab at that, Chuck? You want to tell us who are these organizations we're talking about?
I was listening to a presentation recently. I can't remember where, and what they said was that the data protection framework is a risk-based framework, and size does not matter. So if that answers it, then
so you're saying that me that run the party shop down the road, no offense to the people who sell, because party is a staple in Jamaica, but for me who run that informal business down the road, are you saying that this applies to me because I have risks to manage?
as it stands now, as long as you process personal data. So if the man at the party shop goes strictly by cash and does not take any personal information from you, and by personal information, you know that we mean any information, whether by itself or when put together, can be used to identify that natural living person, or as the commissioner says, a person who has been dead for within 30 years of now.
Yes.
Right. As long as they process data or information that can identify someone, then they will have to comply. So one might want to assume that the party shop vendor may very well say cash, no credit card, no check. And so the risk of the party shop man being caught within it might very well be remote. But perhaps if we wanted to talk about the person the shopkeeper, for example, who gives credit and keeps that book in which they set out the persons who owe and when they are supposed to pay, or that person who runs a partner, because Jamaicans are into the partner and so on. It seems to me, without any exemptions in the law, unless it's coming, then they would be required to comply with the law.
But Georgia, if I may,
go ahead.
before the question, Georgia, it looked like you're trying to run, if you don't catch them under data protection, you won't catch them under proceeds of crime. So you're encouraging people to use straight cash so you can serve them from the proceeds of crime perspective. That's what it's called.
Listen, Chuck, that's a whole nother discussion. You know that, right?
That's where Georgia was going, but I think it makes a very important point in the sense that when the Act defines the data subject, it's very specific in the use of the word individual. So it brings it home to everyone that you're talking about a natural person, a natural being. However, when it defines the data controller, it speaks about the person. And we know that a person can be a legal person as well. So while there's a lot of focus on organizations, entities, companies, businesses, as Georgia made the point, it doesn't end there. Our Act in its wording does not expressly limit it to any kind of corporate body, so to speak, and it can extend to an individual. So as you said, if it is that this person is amassing, collecting personal information and dealing with it in ways that count as processing, which is hard to escape, then technically speaking, the Act could be made to apply to them. And we have to realize that this would be very deliberate on the part of our legislations in trying to force individuals to be mindful of that right to privacy and certainty to ensure that they respect it.
Yeah, I wanted to ask something though, because there's this notion that the Jamaica Data Protection Act protects only the data for Jamaicans wherever they are in the world. I mean, whose data are we protecting? Is this just for Jamaican data wherever they are, or is this for any data that you collect? Can somebody who is visiting the island, in other words, if they are breached, do they have any rights under this Act? Or if we are traveling overseas to another entity or giving our data to an external entity, what are our rights under this Act?
Well, when you look at the definition of personal data, it looks at it in terms of it being a living individual. It looks at it in terms of it being a deceased person for less than 30 years. There's nothing in it that necessarily limits it to a specific nationality or jurisdiction, but everything has to be taken together. So you're talking about data processing by a controller, and there are certain limitations as to who controllers are, and there are certain definitions as to what that processing involves. So technically speaking, there is an extent to which it can have extraterritorial applicability.
Okay. If I may join in on that, from a practical point of view, how other jurisdictions have treated with that very same issue, because our legislation is in line for the most part with the General Data Protection Regulation. They really focus on data subjects within a jurisdiction. So if it is you're traveling overseas and you go into a shop and you're not happy with how the information they are collecting from you, it is not you can't necessarily pick up the phone and make a complaint to our information commissioner and say, I'm not happy with how Walmart is processing my data. So it is really focused, given all the constraints that were identified. When you put all of those constraints together that were identified by the commissioner, it naturally leads to persons in Jamaica.
Yeah. You raised an interesting point there, but Chuck, how would you unpack a recent news article about the parent company for Facebook, Meta, who was fined 1.2 billion and asked to cease processing within a particular time frame? Will those kind of penalties be levied against companies here, or do we have the right here in Jamaica to protect ourselves from the big tech and big data companies such as the one I just mentioned?
Well, that is where we are looking at that person who can protect us. So if it is Facebook, for example, encourages Jamaicans to sign up on their platform. So they market directly to Jamaicans, and we get on their platform and we have a complaint as to how they're using our personal data. Yes, we can pick up the phone or email our information commissioner and make a complaint against Facebook. So although the rights may not follow us all across the world, it does apply to anybody across the world that markets their service to us or surveils us profiles us in any way. So yes, we do have protection, and our information commissioner, by working through other information commissioners that would have oversight over Facebook, she can seek redress on our behalf.
Great.
But might I add, though, that there's another angle to that, because that is actually, because you use the meta experience as well, because what Chuck just dealt with talks about the territorial scope of the data protection law, so that indeed he's correct. If anyone markets, any big tech company, they market to Jamaicans, they target Jamaicans, and we use their services, certainly we are protected in Jamaica. But that meta case that you just mentioned also raises another standard, or brings into account another standard, and that is a standard in relation to data transfers. So the question is whether, if there's an organization in Jamaica that processes personal information in Jamaica and then transfers that data from Jamaica, what are our rights? And we do have rights in relation to that, because that is one of the areas in which you will say, well, first of all, it's processed here, but the standard that relates to data transfers does say that if you are transferring to another jurisdiction, you have to ensure that that jurisdiction has similar safeguards or sufficient safeguards. Now, in relation to the meta case, what I found is that what the European Data Protection Board was saying is that the breach is egregious, because when the data gets to the United States, it's not only that it is actually at risk of being, it's not that it's actually examined by surveillance authorities, because that is one of the issues, but there's also the potential for it to happen. So you can see there that they do not regard that as an adequate measure of protection when your data leaves, say, the EU to the United States. And I've been asking and trying to see if I can get a discussion going around. I know that that situation is Meta and where they store the data, but I still wanted us in Jamaica, given our data protection regime, to have a discussion around whether data that is transferred from Jamaica to be stored in the United States, whether we can say that, or the data controller can say that they are offering that adequate measure level of protection in the United States, given the Meta decision.
As it relates to transfer, though, sometimes we are transferring data. Me being having a technology background, sometimes we're transferring data and don't realize we're using cloud services, we're using Gmail, we're using Microsoft 365. We're transferring data, and we don't realize that we're transferring data. So I guess we have to be mindful of where and the controls around that. That's what I hear you saying, and ensure adequate laws. That's what I hear you saying, George.
Correct. Because we have to ensure that the protections that they offer there in relation to our data is the same that we offer here. Yeah. And you recall that one of the issues there, because one of the fixes that they have, thinking the law, and also they talk about that adequate measures. And one of those that they had come up with was the standard contractual clauses, and they said it's not enough because of the risk when it gets there.
Yeah. Thank you so much, guys. I want to shift gears a little bit, and I want to talk a little bit about the standards, or as in some jurisdiction referred to as principles. And one in particular that comes up for discussion time and time again is this whole notion of fair and lawful, right? So it says, how can an organization ensure that processing data is processed fairly and lawfully? What exactly does that mean? Can you help us to unpack that? Let me jump back to the commission and then go to Chuck, and you're free to chime in. How do we unpack fairly and lawfully?
All right. So when we speak to fair and lawful, we're speaking to several different things. So, for example, you can look at stuff such as, is it that this data was received with the consent of the individual? Mm-hmm. Does the individual know how the data is being treated? Now, you're also looking at other aspects such as, what are the bases on which you're processing it? So if it is that you have some type of contractual obligation that you need to process this data in order to fulfill, then that, of course, will be a factor in looking at lawful processing of personal data. Mm-hmm. If it is that you are processing the personal data with certain interest in mind, the Act speaks to, for example, where processing is being carried out for the sake of some vital interest or some public interest that is going to be protected based on the processing of the personal data, then these would give the data controller some lawful basis on which they may be in a position to proceed. But in each case, you're going to have to look at what the facts and circumstances are, who the data subject is, what the personal data is, and how it is being processed, and to what end.
Great, thank you. Chuck, Georgia, anything to add? I know nobody wants to add after the commissioner, I know, but you know.
So that is where the legislation becomes real to the data subject. Mm-hmm. So the first obligation on data controllers is to let them know how you're processing their data. That's the first obligation. Mm-hmm. And the legislation hasn't left it up to the data controller to decide what you need to communicate with the data subject. It actually tells organizations specifically what you must communicate with them, to them, and by when. So it is that's a mechanism in the legislation that really enables the data subject rights, because if you don't know somebody has your data, you can't enforce your rights against them. So that's the first thing. Data controllers must let them know, and that is a big part of the fair processing. And then the lawful basis. So one thing I'd want to disabuse persons listening, people always are usually stuck on consent as a lawful basis. There are several lawful bases, and from a commercial perspective, it is the weakest basis. There's one exception where that's the only basis that you can process personal data. But in general, if it is because the law says if consent, once you rely on consent, they can take it away as easily as they can give it. What
Right.
happens if all of your customers decide, you know what, we want to lock down your business? So we would have collected everybody's and everybody's personal data based on their consent, and then everybody just come together and say, you know what, I take back my consent. So
Yeah.
from a commercial, Sir Nooks, yeah, they're going to ask
No,
me.
no, no. No. I hear you. I hear you, and it's very interesting. But there's something that I'm looking at time, and there's something
Yes.
that I really want to ask Georgia. Right? There's this thing in one of the acts, right? That in one of in the act itself, and talking about the whole business of lawful basis and all of that. It says if the data has been one of the conditions where you can process it, if the data has been made public by the data subject. What is that really saying? Is that saying if I publish my data like for my social my
Media
social
page.
circle, can someone go and scrape that data from my social circle and use it, like say for instance in a background check type scenario or in an HR scenario, whether or not to employ me? Can they really use that data and process it as one of the basis because I've made it public?
Yes, I would say that prior publication, because if we start where you began, this data protection law is in the context of my right to privacy, your right to privacy. And privacy means that which is not public.
Mm-hmm.
And therefore, if it is that I make that information public, and I like the idea that you use the social media page, for example,
Mm-hmm.
how could you then say that the employer who is doing a background check can process that data in relation to you from, say, taking a screenshot then of your social media page and putting it on their files? How
Yeah.
could you
So
say that? Because it has been published.
yeah, but Commissioner, the law says you can use data for a specific lawful purpose. That's what Standard 2 says. But and you should not use it for any other purpose than that. If I put it out there for a particular purpose, my purpose is to socialize with my grouping, and you take that and use it. Isn't that a breach of my rights?
I'm
So
going to jump, if I may, Madam Commissioner, can I share my view
Go ahead, Chuck.
on that?
yeah, yes, Chuck, you
Chuck?
got to go ahead.
I think he froze. Chuck?
Right. Yes, I'm back. I
Yeah,
don't.
okay.
Right. So remember, there are 8 data processing standards.
Mm-hmm.
So while you can say you have that's a case where there's a sensitive data. So
Yes.
you'd have already qualified under one of the 8 data processing standards first.
Mm-hmm.
I mean 6 lawful bases.
6 lawful bases, yes.
First, okay. Well, and let me break it down for the listener because
Yeah, Chuck seemed to be having some technical difficulties there. So
While we wait, Chuck, one of the things that I just wanted to point out in response to your question, Andrew, is there is a difference between the data subject's purposes in publishing data and the data controller's purposes in processing it. So the
Right.
example that you gave, somebody posts their personal data in whatever form on social media. And as you said, they might be doing it for the purposes of updating friends and family, socializing with their network. The data controller who is accessing that information will have another purpose in accessing it. They don't have to share your purpose for publishing. And so when you're looking at fairness and lawfulness, it is really having regard to the data subject's rights, yes, but also from I'd almost say the data controller's perspective in terms of what is it that controller is seeking to do. That is the lawful purpose that we have in mind.
And if I may add to what you say, Madam Commissioner, we have to, Andrew and Chuck, you know that I talk about my pyro.
Yes.
Yes. I talk about my pyro as a short way of communicating to persons what the act is about. And the thing is, as I say, it is people information, rights, and obligations. So the rights are of the data subject, but the obligation or the duty is imposed on the controller.
Okay, great. Thank you. Thank you so much for
that. There, it's not you have divested yourself to an extent of the right to complain about that which is already public.
Yeah. Chuck was making a point. Chuck, I hope you're back with us.
Yes, I am.
All right, great. You want to complete the thought you had?
I think it was, for the most part, captured by the commissioner. The reality is, although, so you can have it in your organization on the lawful basis that you have published it, but the purposes for which you can use it, it is still restricted and will still be constrained by the data processing standards. And when you speak about using it to conduct a background check, the question is, what is a law? What lawful basis do you need to know if this person gets drunk at a party when he goes out? Or better yet, you need what lawful, if the depends on the scenario that is created. The question is, do you need to know, does that fulfill your dominant purpose for in recruiting an individual?
Listen, I know that's a topic that we probably have to get together. One second, Georgia. But this is a topic that we'll probably need to get together and flesh out a little bit more. Georgia, I give you the last point on that because I'm mindful of time and I want to leave some time for questions from the audience.
Right. So what I was going to say is that we have to speak our focus, because remember that one standard is lawfulness and fairness, and you always have to go back to that. So when you ask about the prior publication, all that we're answering in relation to that is that it is a lawful basis on which you can publish the information.
Okay, great.
Remember
but then you have to flesh out all the others, right? Like purpose and all of that.
Because of purpose, data minimization, and so on. Yes.
Okay, great. Thank you so much, guys. I want to touch on one thing that we get questions about all the time. One other thing, and that's the data protection officer. Who needs a data protection officer? What's the skill set of a data protection officer? And does everybody need one? I'm repeating myself there, right? I said, who needs one? Let me start with the commissioner. Commissioner, it's late evening, forgive me. Who needs a data protection officer?
All right, so on a strict reading of the Act, not every controller needs one. The Act specifically requires certain types of controllers to have a data protection officer. So, for example, public authorities don't have a choice. If you qualify as a public authority, and that's very widely defined under the Act, then you need a data protection officer. If it is that you are processing data on a large scale, then you're also required to have a data protection officer. Similarly, any person or organization that processes sensitive personal data or data relating to criminal offenses, those persons will also need to have a data protection officer. There is provision in the legislation for the commissioner to be able to prescribe other persons or other categories of controllers that will require a DPO, but for now, those are the categories that are already stipulated in the Act. Now, the DPO has a very important function because I like to say that the DPO is not the controller's DPO. The DPO is engaged by the controller, but the DPO is serving a purpose that is for the benefit not just of the controller, but also of the data subject and of the commissioner.
Yes.
So in relation to the data controller, the DPO is there to ensure that they are complying with the legislation. And so the data protection officer has to be in a position to, first of all, have access to the different processing activities, to be able to observe them, to be able to make an assessment as to whether the 8 standards that are set out in the Act are being met. The DPO, however, also has an obligation in the event of any contravention to not just report it to the data controller, but to make recommendations as to how they can rectify or treat with those situations. And if not properly addressed or addressed within a reasonable time, then DPO has a duty to the commissioner to bring that to the commissioner's attention so that the commissioner may intervene. But most importantly, because this act is there to protect the rights of individuals, persons have to recognize that one of the key functions of the DPO is to facilitate the data subjects in exercising those rights. So when the act speaks to the data subject having a right of access, for example, to know what information is held, how it is being processed, who it is being disclosed to, what is the purpose of the processing, there must be somebody as a point person who is there to receive these requests and certainly to provide the responses that the data subject needs. And in the event that the data subject has a complaint about how their information is being processed, then certainly, because the first recourse is to make that complaint to the data controller, the DPO is there to assist the organization in managing those complaints and the response process as well.
Thank you so much, Commissioner. One second, let me jump over to Georgia. Georgia, can we just pick up anybody in the organization and say, hey, you are DPO? Where, who can really function as a DPO in the organization? Where should this function really sit if the organization needs one?
Well, the DPO sits in a position that enables him or her to report directly to the C-suite or the board of directors, because the function is so important and the liability in relation to that, to the organization, the liability of the is so critical that it is important that he doesn't have any obstacles. The other thing about the DPO too is that there must not be anything that compromises the independence of the DPO. So you can't give the DPO a function. You can't take the DPO from a function that requires, one would say, loyalty to the organization and use that person as a DPO. Rule of thumb, I often say to people that if you already have a compliance function or probably internal audit function, then you could consider putting your DPO in that department. In terms of your DPO as well, I find that once your DPO is someone who understands what the law is, understands what their role is, and have a good grasp of what is required to comply with the data protection law, you can use that person. But the key thing is that he or she must not be in a position that places them in conflict with their duties to the data subjects and to the commissioner, on reporting to the commissioner as necessary.
Great, thank you so much, Georgia. I know we're about 10 minutes out from time, and I want to give each of you an opportunity to comment on the meat of the matter, really. If you could take a minute to just tell us, how does an organization, large or small, how do they go about starting their program? How do they go about starting? And I know Commissioner mentioned, consult one of us, right, Chuck? Consult one of us. But if you, you don't know where to start, you figure more or less that you don't have the wherewithal to contact somebody, you want to do something internally, you want to start, by understanding first, what do you do? How do you approach this whole data protection implementation? And I want to ask the Commissioner something about that, follow up on that too, Commissioner. And I want you to hold this thought for me. Is it about registration or is it about compliance? Chuck, you first.
Thank you. So it is, so we understand, you established from the beginning, this is not only for the big organizations. Big organizations have the resources to contact you or a consultant. The challenge is for a member, for a programmer or IT, someone that offers IT managed services, or an individual lawyer or an individual doctor, they will be challenged. So to tell them that they can go and start identifying the personal data and they can go and start doing these things by themselves is challenging. So one of the things we have sought to do, we have looked at the implementation of this, getting people ready to register over the years, and we've really sought to simplify it into a do-it-yourself solution, because there is no 10 steps you can tell somebody for them to confidently go and register. So as I said, we have Design Privacy has looked at all of the issues and say, okay, for that small company, for that person, that 2-man and 1-man shop, we have actually tried to create a solution to answer that question, because there's nothing we can confidently tell them in 10 minutes or 1 hour that would put them in a position to be adequately register with the Office of the Information Commissioner.
Thank you. Thank you, Chuck. Celia, Commissioner, is it about registration or is this about compliance with the Act?
It's about compliance. Registration is one of the ways by which you go about complying with the Act. When you look at the requirements under the Act for a data controller, you're talking about registering, which is a first step in allowing us to recognize who is operating in this space, what types of processing activities they're doing, what types of information are they dealing with, and to a certain extent, to identify some of the risks to which that information might be placed. So registration is just putting the Office of the Information Commissioner in a position to know who the controllers are, and to have that kind of baseline information to know what exactly we are tracking and monitoring and how we will proceed in terms of any enforcement activities. But that's step one. Once you have registered, you still have a duty to ensure that you are complying with the legislation. So you have to be complying with the 8 standards. You have to be making sure that you enforce, well, not enforce, but recognize and facilitate the data subject rights. If you're not doing that as a registered data controller, then you're already in breach of the provisions of the Act. So we ask persons, yes, to get ready for registration on December 1, but we also ask you to ensure that what you're putting in place is something that you're going to be able to sustain in the long term going forward. And in this regard, you have to ensure, one, that your staff or your users, the persons that are acting on your behalf, are also sensitized. They know what the Act is about. They appreciate what your obligations are, what their roles are in terms of assisting you in meeting those obligations. You also have a responsibility to make your clients, your customers, the persons whose data you keep, aware of the steps that you are taking to protect them. So for example, where you're required to appoint a data protection officer, it's not just about ticking that box and saying, yes, I have one. You are required to make the public know who your data protection officer is, so that they know who they can reach out to for assistance. So there's a lot that goes into compliance, and it's not just a registration.
Yeah, great. Thank you so much. Ladies and gentlemen, we're almost out of time, and I want to pause to just jump to the chat for a second to see if I can pick up some comments. I see Eric Williams is saying, when will we get to consequences for non-compliance and impact on the organization, especially as it would impact their bottom line profitability and credibility? Credibility, right? Georgia, you want to take that? Is there going to be any consequences for this? Does this act have teeth?
Well, it does, but what I normally tell persons is that, yes, the fines are there, that 1 million fines from 1 million to 4% of the data controllers' annual gross revenue, or imprisonment for up to 10 years. There's that. But I always say to people that it's more than about compliance, because you have to build confidence in your brand. And so the reputation of your brand is a big deal. And also recognize that this is why I think we started by talking about a framework. I think it was Chuck who talked about a framework. That is why you need to have that framework in place, because it's It's a framework which enables you to respond quickly, for example, to incidents or data breaches, to have those policies and systems in place. It enables you to, it's a framework that enables you to continuously demonstrate or to be able to demonstrate that you are in compliance. It's a system that enables the entire organizational culture to change because of the duty that you have to build trust in your brand.
Yeah, great. Thank you so much, Georgia. Commissioner, I think this one is for you. How are we going to get big tech to abide by this act?
Well, I think it was Chuck who mentioned earlier about the reach of the legislation, or it might have been Georgia. So notwithstanding that companies might be operating in another jurisdiction, our legislation does model the GDPR and is very similar to the UK DPA and other legislation. And in that regard, we are able to work collaboratively with other information commissioners, if necessary, in terms of any enforcement proceedings.
Yeah, I have Sherry Williams that's asking, and this is for the panel. Are there free services to educate startup companies? They say, I find this confusing. And I do recall the minister of ours in his sectoral presentation saying that, hey, there will be awareness campaign. Certainly myself, Georgia, and Chuck, and several others, Grace Linda and several others have been on the circuit from far back as 2018, trying to educate and giving our opinion on what needs to be done. And there are examples in other jurisdictions, persons who are way ahead of us in terms of implementation. So there are a lot of information out there, Commissioner, but what's the plan in terms of educating the general population on these data protection and what companies and individuals need to do?
Right. Thank you for that, Andrew. As you mentioned, there is a lot of information available online that does provide guidance at different levels to individuals, from very short and simple advertorials to more detailed and complicated exposes on data protection and its requirements. But on a local level, and certainly from the perspective of the government and the regulators, we have embarked on a communication campaign which will see us putting out information on the implications of the Act and the requirements for data controllers using different medium. So, for example, our office has already started publications in the most widely read newspapers dealing with different aspects of the legislation or its impact. The ministry, working collaboratively with us, will also be putting out various material. We will be utilizing social media websites. We are in the process of developing our own website, which we will use to disseminate information to the public, the ministry as well. We do have a plan that will utilize interviews, talk shows, various forms of communication via radio and TV as well. So we recognize that persons are hungry for greater information regarding data protection. And as we go forward, particularly in the next 6 months leading towards registration and the full implementation of the Act, you will see more and more information coming forward. But we also encourage persons who have any questions or comments to reach out to the office. We have been getting requests for whether clarification on different aspects of the Act or from time to time for sensitization for different persons or sectors. And the office has been providing sessions directly to various organizations. We have also participated in several forums such as this one in collaboration with different organizations. I know, for example, the Ministry of Education and e-learning have been working in terms of putting together various events for the persons in the education sector. In a similar way, we have called upon and have encouraged other sectors to get together in groups and put together events, which we are happy to participate in to the extent of our resources. But certainly, as much information as can be shared will be forthcoming over the next few months and going forward.
Thank you so much. Ladies and gentlemen, listen, when we get together to talk about this topic, 1 hour is hardly enough. When I reached out to Georgia earlier to say, you know, these are some of the questions we want to answer. She's like, how many sessions are we going to have? Because each of these questions is a session by itself. How many 1 hour sessions? But hopefully we got a chance to touch on most of what you know, persons are concerned about, but there will be more sessions like this. I want to take time out to say thank you so much for this, for all our panelists, our Commissioner Celia Barclay, from Design Privacy, Chuck Cameron, let me just stop right there, and from PLMC with the Pyro framework, Georgia, Gibson, Henlin. I'm Andrew Nooks. I'm with Symptai Consulting, and you know, as Chuck mentioned, we are also service providers in the privacy space with training and sensitization and all that. I want to just pause whilst I say thanks to the panel, just to highlight some things from this organization, the JTDA, that has been doing some wonderful work, and we are seeking persons to you know, get involved with the JTDA, become one of our members, and get exposed to some of the benefits. And I'll just read to you some of the benefits of joining with JTDA whilst we close out this presentation, and say thank you and round of applause to our panelists for this great presentation and for taking time out in a late evening to keep persons engaged and interacting. It says, you know, we certainly hope that you found the discussion you know, very valuable. And remember, the Data Protection Act is a game changer in today's digital landscape, and being prepared is key. Stay ahead of the curve by implementing the necessary measures to protect your data and uphold privacy rights. We'd like to extend our gratitude to our guests, as I've done before, right? And this is a message from JTDA. But if you are not a member of the JTDA, formerly the Jamaica Computer Society, and for those of you who are familiar with JITSA, this is a combination of both entities. Listen, don't wait anymore. Visit our newly revamped website at jtda.org, sorry, and you know, look at some of the videos of the participation that we made in the JCF transformation event, which everybody says that event was a winner. There are opportunities for networking and collaboration. Become a member. You can expand your network. You can forge valuable partnerships. You can get help with your privacy program. There are industry insights and updates through events, webinars. You know, the next webinar will be sometime in June, right? So look out for that. Look out for the flyers. Look out for the social media advertisements on that, right? The organization serves as a collective voice, advocating policies, initiatives, and regulations, and promote innovation, entrepreneurship, and digital inclusion. Members will have the opportunity to contribute to important discussions such as this one and make a meaningful impact. So I'm going to invite you to stay tuned for further updates. Until then, stay safe, stay informed, and keep embracing the power of technology to shape a better future. JTDA, we're providing access, influence, and empowerment through technology. Thank you very much, ladies and gentlemen. Thank you so much for joining us. Thanks again to our panelists. You know, we hope you found this very interesting and informative. Thank you.